Hi, this is Halvorsen from Pastor-Juror, and welcome to the Pastor-Juror podcast on juror misconduct law, where our motto is, don't let juror misconduct taint your verdict. We analyze current state and federal juror misconduct cases and provide attorneys with strategies to identify, preserve, and advance juror misconduct issues at trial and on appeal. And today we're going to be looking at the case of Halvorsen v. White, which is out of the U.S. Court of Appeals for the Sixth Circuit. The issues we're going to be discussing are Bible-related juror misconduct, procedural default, the juror as a pastor, and the scripture-quoting juror. Glad you're listening, because the only evidence you want the jury to hear is in the courtroom. Now let's take a look at Halvorsen versus White. Hi everyone, this is Halvorsen from Pastor-Juror, and in today's podcast we're going to be looking at the juror misconduct issues in the case of Halvorsen versus White, which is from the U.S. Court of Appeals for the Sixth Circuit. This case was decided on August 20th, and I'll be sure to put the full citation in our episode description. And please, if you can, leave us a review because we want your feedback and want to provide value to our listeners. Now, the issue we're going to answer in today's podcast is this. Is there juror misconduct when a juror who is a pastor with strong religious convictions quotes scripture to support his views on the death penalty in this case, where the defendant was convicted of murder? Now, I have a feeling you may be surprised with the answer to our question, but remember that in juror misconduct cases, the facts are heavily weighed and become pivotal to the outcome of the case. Here we're going to be talking about juror misconduct claims that are procedurally defaulted and whether the defendant can show a good excuse for that procedural default. So maybe I'm giving you a little hint as to how we're going to answer our question. Here, the defendant was convicted of murder in 1983. He first raised the issue of juror misconduct over 20 years later in 2004, which was supported by the affidavit of his investigator who interviewed juror Garlington, that's the pastor-juror in this case, and argued that Garlington incorporated the Bible into the penalty and sentencing phases of deliberations. The district court denied the petition for habeas corpus, and the U.S. Court of Appeals for the Sixth Circuit affirmed that decision. So let's dive into the facts. As I said, Halvorsen was convicted in 1983. In 1985, the district court gave him leave to interview jurors who were willing to discuss the case, and 2 of them agreed. The district court found that Halvorsen could have discovered any potential misconduct then as to Pastor Garlington. The court noted that Garlington was clear about his religious convictions during voir dire, exclaiming that he was a pastor and quoting biblical passages in response to questions about his views on the death penalty. The court also noted that at the end of the trial, with the court's permission, Pastor Garlington led the courtroom in prayer, thanking God for coming into their midst and guiding them all. So the question is, why did it take Halvorsen so long to bring up a potential juror misconduct issue? So you better be thinking about waiver and procedural default. Now, the U.S. Court of Appeals also stated that Halvorsen brought his 2004 motion under the wrong statute. The case originated in Kentucky and then went through the federal court system. The Court of Appeals added that Kentucky courts routinely deny review of juror misconduct claims incorrectly brought under Civil Rule 60.02 rather than Criminal Rule 11.42. Considering the fact that Halvorsen interviewed 2 jurors in 1985 and could have learned of any alleged juror misconduct, and the fact that his 2004 motion was brought under the wrong statute, the U.S. Court of Appeals said that any request for an evidentiary hearing was denied. Additionally, since he pursued habeas relief and it was determined that his claim was procedurally defaulted, there was just no excuse as to why it took him over 20 years to bring his juror misconduct claim. Now, there are a few things I want you to consider here. First, if you have a situation in a death penalty case where you have a juror who is a pastor and is quoting scripture on the death penalty, or the juror doesn't even have to be a pastor. It's just a juror who is quoting scripture on the death penalty. Flush out the juror's opinions in as much detail as possible to provide evidentiary support in the record. What do I mean by this? Well, one way is find out, is the juror's mind already made up before he or she has heard any evidence? Because remember, if we see any potential juror misconduct, the record must demonstrate that it prejudiced the defendant in order to get a new trial. Second, in this particular case, the pastor-juror is quoting scripture. Now, in these situations, get down the biblical verse or the verse from whatever religion is being utilized by the juror, and also make sure to get the specific translation edition of the Bible, meaning is it the King James Version or the NIV or something else, because different translated versions may read slightly differently. And so it's important to get that information into the record. Then you want to find out if the juror is relying on that passage and how they are relying on it. A typical example that we've seen in cases in the past is the biblical verse of an eye for an eye, that particular passage. Now, you want to build the record and then demonstrate the prejudice, because if you can't demonstrate the prejudice, then you're not going to be successful in your appeal. Now, I want to make clear that I am talking about both sides of the record for this, whether you are representing a defendant in a death penalty case where they're quoting scripture, or whether you are representing the people or the state, you're the prosecutor. It is important to make the record clear. Ask the questions so that you get the answers in the record. If you're for the prosecution, you want to squash out the idea that there's any sort of prejudice. If you're for the defendant, you want to build the record to show that there is prejudice and how the juror may have relied on the passage and how that affected his or her particular verdict and how they arrived at the verdict. And then always think about procedural default or waiver. A red flag here is that it took the defendant over 20 years to bring up the juror misconduct issue. If you could have discovered a potential juror misconduct issue at the time of trial, bring it up then, or it will be procedurally defaulted. And that's it for our analysis, the juror misconduct issues in this case. If you like what you hear and want more, please subscribe to our podcast and leave us a review. And also check out our latest CLE on juror misconduct called Facebook and Today's Juror, 2017's 10 Biggest Juror Misconduct Events, and use the code PODCAST25 for $25 off our CLE price exclusively for our podcast listeners. This CLE is accredited and or approved in 30 states for a minimum of 1.5 general CLE credits. That's it for today. This is Negan Zahauer from SM Juror. And remember, don't let juror misconduct taint your verdict. See you next time.